Welcome to this episode. Today we are going to discuss the right to liberty, which the Constitution grants every individual. Now, the right to liberty is something, it's topical. It's an everyday issue. It's something that is with us every day, and it's something that we have to, be at peace with. It's something we have to reconcile ourselves with in order to have a quality life, essentially. The right to liberty is provided for in section 35 of the 1999 Constitution. Sub 1 provides that every person is entitled to his liberty and no person should be unlawfully deprived of such liberty save in accordance with the provisions of the law. Subsection 1 moves ahead to provide certain exceptions. We'll just run down the whole sections and come back to the very, very critical aspects of the right to liberty. Now, Sub 1 provides that the procedures and such exceptions where the right to liberty may be infringed upon. Sub 1, that's Section 1, Sub 1, Paragraph A, provides that where a person's liberty can be interfered with in execution of the order of court. That's where a court has given an order that will warrant the interference with the liberty of an individual. Now, such interference, if within the confines of the order of court, will now be deemed not to be an infringement of the right to liberty. Secondly, is where the person has failed to fulfill an obligation which is imposed upon him by law, and of course, such person, the liberty is deprived in such a way to make sure that he fulfills that obligation that's already been imposed by law, then such person's right to liberty will be deemed not to have been infringed upon. Then again, Paragraph C talks about where a person is brought to court in execution of an order of court, or where a person has been reasonably suspected to have committed a criminal offense and is now arrested or detained pursuant to being brought to the court so that his guilt or innocence will be determined. And also the subsection also provides for where a person actions that are reasonably necessary to prevent a person from committing a criminal offense. That also will not amount to an infringement of the right to liberty. And Paragraph D talks about for persons under the age of 18, their liberty can also be interfered with for the purpose of their care or education. For the purpose of their care or education, their education and welfare. Now, Paragraph E talks about where a person is of unsound mind, where a person is mad, or where a person is an alcoholic or a vagrant or a drug addict. In such situations, the person's right to liberty, the person's right to act as he wants can be restrained. But the qualification is that it must either be for his care or treatment or for the protection of the community. So in these circumstances, and where a person, for instance, is infected by a contagious disease, where a person has an infectious disease, his liberty can also be interfered with so that, for instance, to give him treatment or to protect him from infecting other members of the community with the same disease. Then where a person's liberty can also be interfered with, for instance, to effect a lawful extradition, where a person is unlawfully in Nigeria, for instance, the person can be arrested and now processed to be taken out of Nigeria. Now, where a person also is needed elsewhere, maybe there's a need to take a criminal outside for him to maybe for a trial, a criminal trial, then the government, the police or any other relevant government agency can arrest the person and, of course, make all the processes, fulfill all the processes, and then facilitate his being taken away to the foreign country that requires him to answer for whatever offense he might committed. So, in order to effect lawful extradition, a person, or to make sure that nobody enters into Nigeria unlawfully, a person's liberty may be interfered with. Now, these are the exceptions under subsection 1. Sub 2 talks about that a person who is even arrested must never be allowed to stay in detention more than the period provided for the offense for which he's charged. So, for instance, if you're charged for an offense, maybe stealing that has 3 years, nobody should keep you in detention more than that 3 years without a trial. That's the effect of subsection 2 of section 35. Now, sub 3 talks about your right to remain silent. When you're arrested, when you're being detained, you have a right to remain silent and not say any word until you have conferred with a legal practitioner or any other person of your choice. Now, before we go back to talk about the right to liberty, let's talk about this right now. It has been further elaborated by subsequent laws, like the Administration of Criminal Justice Law, even the Police Act, the 2020 Police Act. They all make provisions that when a suspect is arrested, that he has a right to remain silent. This is the source of that right of a suspect to remain silent. A suspect is not under any duty to volunteer statement to the police. When a suspect is arrested, he may choose, and I repeat, he may opt not to give any statement to the police. And if he volunteers his statement, for that statement to be valid, for that statement to be admissible in court, it must be endorsed, it must be signed by his own legal practitioner, that's his own lawyer, or any other person of his choice. And what this means is that statements in the police station, usually when you get to the police station, once you're arrested, some police stations go as far as saying that for you to be released, you must volunteer a statement. Now, this is now clearly illegal and an infringement. It's unconstitutional. It's an infringement on the right to liberty. You can't impose more duty than the law has already imposed. The Constitution has made it very clear that a suspect who is arrested has a right either to volunteer statement or to refrain from saying anything. And when he says something, for what he says to be used in court, it must be signed by either a lawyer or any other person of his choice. Section 17 of the Administration of Criminal Justice Act and Section 17 again of the Administration of Criminal Justice Law of Enugu State, they all make this provision. I think Section 32 of the Police Act 2020 also makes that provision, that the statement must be taken. If statements are taken, if they are volunteered, if the suspect chooses to give statement, for it to be valid, it must be in the presence and endorsed by his legal practitioner. Now, subsection 4 talks about that a person who is arrested must be brought to court within reasonable time. Now, we often witness situations where a person is arrested and he's in the police station for more than 3 days, sometimes weeks, sometimes even months. We have witnessed many cases where people are detained indeterminably without being taken to court. Now, what the Constitution provides in sub 4 is that when a person is arrested, when a person is accused of committing a criminal offense and he's arrested, he must be charged to court within 24 hours, within 1 day. Yes, if there is a court within 40 kilometers radius of where the accused person, the defendant, was arrested. Now, what it means is that if a person is arrested and there's a court within 40-kilometer radius and is not charged to court within 1 day, his right to personal liberty has been infringed. Now, the law goes on to provide in sub 5 that where there's no court within 40 kilometers radius, where there's no court within 40-kilometer radius of where the accused person was arrested, then any further period that the court deems reasonable in the circumstance may also be accepted. So if there's no court, for instance, if the person is a very remote area and the court is very far away, now the court will consider the whole troubles that the authorities will take in bringing the person to court, and will consider that some of those efforts might not yield any result within 1 day. So the court requires that it must be within 2 days or any other period. If it's beyond 2 days, then there must be an order of court to allow that. So detention in police station, detention in any other place, in any other government agency, by any other authority, must terminate within 2 days, whether not minding the distance. If it has to exceed 2 days, then there must be an order of court. The court must extend that period. Now, when we talk about subsection 6, Subsection 6 of section 35 talks about the right to compensation. A person who is unlawfully arrested in any of these circumstances already listed. If a person is arrested in any of these circumstances, in any circumstance that infringes his right to liberty, the Constitution provides that that person is entitled to compensation. That person is entitled to public apology. Now, in Jim Jaja and the Commissioner of Police of Rivers State, in that case, the Jim Jaja was arrested, he was detained by the police in Rivers State. He sued them for infringing his right to liberty. But he did not claim any damages. So the court said that because he didn't claim damages, that they will not grant him damages. Now, both the trial court and the Court of Appeal refused to grant him damage. They upheld his right to liberty. They said that his right has been infringed, but refused to grant him any remedy, because under the common law, ordinarily, if you're claiming for damages, you must prove the damages. But the Supreme Court in Jim Jaja, in the case, now held that whether an applicant for the enforcement of his fundamental right, that's for the enforcement of the right to liberty, whether he claims damages specifically or not, whether he claims damages particularly or not, that the court has power under this section, subsection 6 of section 35, to grant him damages. That he does not need to claim damages, and that whether he claims or he fails to claim, that he will be awarded damage, because subsection 35 sub C provides that he's entitled to damages. So whether he claims it, he asks for it or not, he's entitled as of right. Now, sub 7 makes some exemptions as it relates to the time within which a person must be brought to court. Where the offense is a capital offense, we've talked about the capital offense. The capital offenses, they include murder, armed robbery, treason. These are offenses that if you commit them, the punishment stipulates the death sentence. The subsection 7 of section 35 provides that once a person is charged with these offenses, the court, his right to liberty, his right to be brought to court, and to be brought to court within 24 hours, and either to be tried and released immediately, will be stayed. It will be abated. It will not run. Once a capital offense is involved, a person could be detained beyond the 24 hours. That's what subsection 7 provides. That the right to liberty, the right to be not to be detained by the police, that once the capital offense is the subject of the charge, that right will be stayed. It will be, it will be in abeyance. It won't apply to that person. In as much as the due process of law usually is followed, like the person is usually remanded on the order of the magistrate, but the person is not entitled to bail. Once you're charged of capital offenses, you're not entitled to bail. Bail is not a matter of right. It's a privilege that the court might grant considering the peculiar circumstances of the case. But for any other offense, bail is a matter of right. And now that we're talking about the issue of bail as it relates to capital offenses, it's also good to talk about when bail is not a matter of right. For instance, when you have been convicted of an offense, if the trial court convicts you of an offense, your presumption of innocence collapses and you're not entitled to your liberty as of right. You now have to adduce evidence before the Court of Appeal or an appeal court to show why the court will grant you back your liberty. So before you are convicted, and once the offense is not a capital offense, you are entitled to bail as of right. But once it's a capital offense, you're not entitled to bail. And once you have been convicted, you now have to show special circumstances why your liberty must be granted you. Now, this is like a summary of the subsections of section 35 which provides for the right to liberty. Let's go back to the most contentious area of the right to liberty, and that's section 35 sub 1c, which provides that a person's liberty may be interfered with in order to bring him to court when he's suspected of having committed, reasonably suspected to have committed a criminal offense, or to any reasonable actions taken to prevent him from committing such criminal offense. This is where the police and the authorities, that's government agencies. This is where we have the most contention, because this is where the power of the police, as provided section 214, 215 of the Constitution, creates the Nigerian police. Now, section 4 of the Police Act gives them powers to investigate, to preserve law and order, to protect lives and property, to enforce all the laws in Nigeria, to prevent and to detect crimes. Now, the same power, this same Police Act, and also the Administration of Criminal Justice laws and acts, laws of states and the act for the federal government, they also give the power to the police to arrest and to detain. Now, section 35 1C, that's this exception to the right to liberty, is where the right to liberty of individuals come in close contention to the right of the government and the power of the government to ensure an orderly society, to ensure the security of the communities. Now, this is where the right of the whole society comes into contention with the individual rights of one person. You have your right to, of course, your liberty. You determine where you go. You can choose to go to anywhere you please. And now, but section 35 1C brings into focus where the right of the government to protect lives and order, the right of the government to ensure the security of the whole community, comes into close collision with that individual right of determining how you want to live your own life. And this is how the court has defined relationships here. Of course, we have already said that the police, the government, they have their own powers. Now, the individual has his own rights. Now, how has the law gone ahead to make for an agreeable circumstance, an agreeable situation where these rights don't collide, but they just correlate. Everybody stays within his own sphere and nobody steps on another person's toes. Now, this is what the court has said. If you look at the provision, it uses the term reasonable a lot. So the court has gone ahead to interpret that for a person to be arrested and detained, there must be a reasonable suspicion. Now, in COP, Commissioner of Police and Obolo, the court held that for suspicion to be reasonable, before I get to that, we all know that if there's a crime, usually people take complaints to police. Now, police, based on the complaint, now acts. Sometimes the police can act without a complaint. They can see where an offense is being committed, and they can just come in, arrest people there, and take them to court. So the police power of arrest, maybe we should talk more about it. The police power of arrest, police have the power to arrest either with or without warrant. Now, where an offense is committed in the presence of a police officer, he can arrest. Where a complaint is brought to the police, they can also arrest. But there are provisions, there are offenses. For instance, if you look at the offense of sodomy, that's homosexuality, that's these offenses of unnatural sexual intercourses. Most of the sections, most of the provisions of the law enacting these crimes, these offenses, they stipulate that an offender can only be arrested with a warrant. So in such situations, a police officer must obtain a warrant to effect an arrest. But in other situations, for instance, where an offense is committed before an officer, he can just go ahead and arrest the offender. Where somebody brings a complaint, he can go and, of course, arrest the person. So, but the court now held that for a person arrest to be deemed, for police to have reasonable suspicion to arrest anybody, there must be in existence objective facts. That's that there must be an allegation and there must be evidence to support a police officer's decision to arrest. That it is not his own judgment alone, but it's an objective judgment considering the whole circumstances of the case. The police, the decision is not his, it is his to make, but the factual circumstances surrounding the decision must be objective. There must be reasonable suspicion at the time of the arrest, not a futuristic suspicion. Not that you look at this person and maybe you look at the way he looks, you look at his dressing, or you look at the way his mannerisms, and you now conclude that people that behave like this, that they are criminals, and you now go and arrest him. In such situation, because we see some of these things happen every day. Like, people have been stopped, and because of the way the haircuts they have, then police will arrest them. People have been stopped, and maybe they will now look through their phones and they say the kind of messages you have in your phone, that these messages and they will arrest them. No, what the law envisages is that for your right to liberty to be interfered with under section 35 sub 1 paragraph C, there must be an objective basis, an objective suspicion, not just the judgment, the private judgment of the police officer. Also in Agundi, in Commissioner of Police and Agundi, the police also held that those situations must exist before the police, the officers, any relevant authority, any relevant agency of the government will take an action that will interfere with the liberty of the individual. Such suspicions must exist prior to the arrest, prior to the detention. Not that you now detain the person and now begin to find the reasons for the arrest and you now justify the arrest retroactively. No, there must be objective basis for effecting the arrest. And the courts have also, in Pawemi and the Gani Pawemi and the Inspector General of Police, also in Iselanume and Joyce Amadi, the courts have held that once a person is arrested, once a person is detained, once it is found that his arrest was unlawful, it does not matter the length of detention, whether the person was detained for 2 hours, or whether the person was detained for 4 days, or whether the person was detained for 3 months. Once the arrest is unlawful, whether you detain the person unlawfully for 2 minutes or 3 minutes or 30 minutes, the courts have held that the person will be entitled to damages, as we talked about before. He will also be entitled to public apology. Now, we also want to look at some other issues that come up in Ugochukwu Duruaku. It's a court of appeal case, and Sir Gilbert, Nwoke, the court examined the power of arrest, examined this thing how we come to a balance between the government's interest in having a society that is ordered, a society that there's security, and then the individual's interest, the individual's right to liberty. And in that case, the court held. In that case, what happened was that some members of Pengasen, that's a petroleum trade union, they wanted to embark on strike. They wanted to, suspend supplies of petroleum products. And, some factional body now reported to the police, and the members of the executive of the body, they were all detained because it was in a festive season, and by going on strike, the supply of petroleum products will be really affected. So the government felt that by arresting these people on time before they take the decision to go on strike, they will now forestall them from interfering with the mood of the festive season by now making petroleum very scarce. Now, when the matter got to court, at the Court of Appeal, the court tried to decipher this balance we are talking about, and the court held that there must be investigation before arrest. That arrest, you don't just suspect somebody and arrest him immediately. That for arrest to be legal, for arrest to be constitutional, it must begin by a suspicion. Then you carry out investigation to confirm your suspicion. That is at that point where your suspicion, you now have credible evidence in support of your suspicion, that you now move ahead to arrest. That arrest is not the first step in the criminal process, that's the criminal administration process. That first is the suspicion, then there is investigation. It's only upon investigation and there's a prima facie evidence of the offense having been committed by that particular individual that the police can now move and now arrest them. And of course, because of the provisions in subsection 4 and 5 of this section 35, which provides that the person must be charged to court at most within 2 days, no matter the distance. It now means that the police must have gathered a lot of evidence before they arrest. So arrest is not the first thing. Investigation comes before arrest. But we all know that the present situation is that police, once a complaint comes, they now swing in and arrest you, and they will now probably grant you bail and now commence investigation. That is unconstitutional. That is an infringement on people's rights to the right to liberty. Now, there's also a very funny situation that's becoming very popular now. This is the age of the neighborhood watch, that's vigilante. These are people that communities organize, and of course they help the police in providing security in our communities. Now, some of these bodies have, some states have passed a law recognizing them. While we now hear about the Amotekun in the West, we hear about a lot of the Islam police in Kano and in many other states. And some of these vigilante, they go ahead to arrest, detain, and sometimes even torture people, that's suspects. Now, the law is very clear. These bodies, these vigilante, their right to arrest is the right of every private person to arrest. Private individuals have the right to arrest if an offense is committed in their presence, or if they reasonably suspect another person. That's section 10 of the Administration of Criminal Justice Law. If they suspect reasonably that another person committed an offense, they can arrest. But the condition, the catch, is that once they arrest, and it includes this neighborhood watch, the Amotekun, and whatever vigilante, the next port of call is to take that person to the nearest police officer, or if there's no police officer nearby, to the nearest police station. They have no power of detention whatsoever. They have no power of even questioning. All they have is the power to arrest and hand over to the police. So some of these vigilantes, once they detain you, whether it is a minute or it's 30 minutes, whether it's a day or 3 days, they have infringed on your fundamental right. Once they arrest, the next thing, as the law provides, is for them to hand over to the police station. And we've also seen a lot of other funny situations. We've seen hospitals, after treatment, they will now detain the patient until the person will now fully pay his bill. I cringe a lot at that situation, and it's something that's very common. Like, I had a friend who experienced that not long ago. The hospital, in fact, from the beginning, going to the hospital to get treatment for any infirmity, any sickness, it's contractual. It is not criminal. There's no element, there's nothing criminal about going to the hospital to be treated. And the hospital is not the police. It's not a government agency. Even if it is a government hospital, they don't have the power to arrest or the power to detain. So it is an anomaly. It is unconstitutional, and I think my opinion is that it's even obnoxious. The hospital, they should make provisions. We are in the 21st century. Sign contracts, and if you fail to pay after your treatment, let them proceed in a civil matter in court and obtain their money back, but not detaining the person until he pays his bill. That is an egregious infringement on the right to liberty. And